Boa tarde a todas e todos. Obrigado, Alexandre. Queria, em primeiro lugar, dizer que o papel do mediador não é um papel do micropalestrante. Portanto, apenas tenho uma ambição de pontuar o âmbito jurídico, econômico, científico do debate havido e passar a palavra ao meu muitíssimo professor e colega Ryan Benjamin Abbott. Sabemos que no Brasil nós temos um dispositivo bastante polêmico, que é o parágrafo único do artigo 40 da Lei 9279 de 1996, que é o dispositivo que altera o termo final do cômputo do prazo das patentes de invenção e dos modelos de utilidade. Sabemos também que não temos uma história antiga, apenas antiga, mas costumeira, sobre o que se trata o NPI e as dificuldades do NPI. Desde a junta real, a junta comercial, passando pelo DNPI até o NPI, temos hoje um ambiente onde não há a quantidade de servidores e também toda a estrutura necessária para que, com calma e a qualidade costumeira, que sempre foi muito boa, possamos atender à demanda, à alta demanda de propriedade intelectual e propriedade industrial submetida ao NPI. Daqui para frente eu vou falar em inglês e passar em seguida a palavra ao palestrante. So today we will hear my good friend, my colleague, Ryan Benjamin Abbott, that actually just launched a fantastic book that I had the pleasure of reading about the reasonable robot. Anyone that's interested in artificial intelligence and new regulation of this kind of creation should reach and seek and read Professor Ryan texts. He also has free texts that are online about inventiveness step and what is obvious and it's not, and I would suggest everyone to read Professor Abbott's text. Professor Abbott is of a second generation of IP law professors. His father, Dr. Frederick Abbott, not only has already lectured in previous events of Abifina, but was a very good friend of my deceased father. So the Abbott's clan and Barbosa's clans are friends in the second generation. Today, Professor Ryan will tell us about his experience not only as a physician, he's a doctor, but also as a professor and as a lawyer in the United Kingdom and in the United States of America, with huge experience in patent litigation and patent prosecution. Dr. Ryan has been recently quite famous in the patent prosecution of the Dados case that has been commented everywhere in the world. But today, Ryan will teach us and talk about his opinion considering patent term extension, supplementary protection certificates, and the possible delay of public domain that can affect access to health and access to important technologies. So without further notice, Professor Ryan, please, let's hear you with much joy. Thank you very much.
Well, thank you very much, Pedro, for, as always, an overly generous introduction, or perhaps I should say, obrigado. We were discussing, I have been to Brazil twice, and both times have learned a Portuguese word. First time was caipirinha, then I got obrigado. If I had come for this event, I surely would have learned a third word, but it is good that so many of you are better with languages than I am. In any case, it's a real honor to be back this year after being there in December for Abifina's International Seminar on Patents, Innovation, and Development. And very sad I can't be there this year. It seems a long time ago, last December, but that is also relevant to our discussion today because we are talking about extending patent terms, particularly in the pharmaceutical and agrochemical industries, fields which have some of the most compelling cases for granting patent rights in the first place. And I'm going to primarily focus on pharmaceutical patents, although I do a bit of each, but I have mainly a pharmaceutical background. And I know this morning, which I very much enjoyed, was also mainly on pharmaceuticals. And the pharmaceutical industry, of course, is, and the IP policies that we have around that are going to be critical for COVID-19 efforts. Just this week, they started administering vaccines in the United States, which is exciting news. And they had recently started also in the United Kingdom. I'm still trying to figure out how to get one. And I thought we had really a phenomenal lecture this morning from Ellen, who is, of course, world famous for working in this area. So I will assume everyone has heard that, and I won't go over too much of the same material. But at a very high level, Ellen explained that utility patents have a 20-year term of protection under the TRIPS agreement, which is an international legal agreement between all members of the World Trade Organization, including Brazil. And TRIPS sets minimum standards for patent protection and allows members to provide more extensive protection of intellectual property to do so if they wish. And many nations, at least in some contexts, do just that. We call these sometimes TRIPS plus protections, and you heard about some of the ways in which the EU is providing TRIPS plus levels of protection, and I think also a skeptical view of whether doing that is good or beneficial. In the context of patents, the United States and Brazil also provide some TRIPS plus protections, including extensions to patent terms, including allowing patent protection for more than 20 years from the filing date of a non-provisional application, which is the minimum required by TRIPS for utility patents. And as you've heard the EU situation on some of these topics, I'll focus a bit more on the US and also try and put it in the context of Brazil. In particular, I'm going to speak about Article 40 of Brazil's industrial property law, which provides a 10-year minimum term of patent protection. I'm going to talk about parallel importation, and I'm going to talk a bit about US patent term extensions, which are broadly similar to SPCs, which Ellen discussed at length today. After that, I'll talk a bit about how some of these differences have impact on competition, on healthcare, on drug development, and then offer a few suggestions for what Brazil might do to move forward more effectively. I'm certainly not an expert on Brazilian patent law, but I do know a few pretty good Brazilian patent attorneys. And if there are any mistakes here on that front, it just means I wasn't paying enough attention when they gave me a lesson. So I think a first system on which Brazil is a bit of an international outlier is the fact that Brazil automatically provides 10 years of patent protection for an issued patent, regardless of when the patent was filed and whether a patent holder has suffered actual damages for the delay. That is not a common feature of national patent laws. It's not something that, say, the US or the UK does. And if the Brazilian Patent Office tended to spend a couple of years evaluating an application, that might not be so much of an issue. But it becomes a significant issue where it takes more than 10 years on average for a patent to be issued. Because once more than 10 years have passed during examination, this means that Article 40 gives patent holders additional patent life. Indeed, in Brazil, close to half of issued patents take longer than 10 years to be issued. So a very significant number of patents are benefiting from this article. In fact, certain types of patents have historically had significantly longer waiting times, 13 years on average for pharmaceutical and telecommunication patents, and with an average pendency of 13 years in examination. That means that certain patents even have longer examination timelines. Some have been closer to 20 years of examination time. If you contrast that with the United States, the most recent data is that it takes on average 14 months to get a first office action, and the entire pendency process of a patent is less than 2 years. So from the time of filing a non-provisional application to the time of either getting an issued patent or not, in the US on average, that takes less than 2 years now. And in Brazil, when you combine a minimum 10-year patent term with a backlog like this, it has a few important implications. For example, pharmaceutical drugs may be protected by patents for longer in Brazil than they're patented abroad. And that means there may be cheaper generic drugs and decreased prices for originator drugs due to generic competition in countries like the US, in the UK, in other countries in South America, years before you have the same situation in Brazil. That generally doesn't end up being the case in the United States, although for a variety of other somewhat complicated reasons, the US may end up having higher drug prices than other countries, which we could talk about perhaps later. Now, the US does have a patent term adjustment provision, and that applies for patent office delays. It applies where the US Patent and Trademark Office has failed to meet certain deadlines, or to issue a patent within 3 years of the filing date, or where there are delays due to interferences, secrecy orders, and successful appeals. Deducted from that time are times during which an applicant caused a delay, for example, by not promptly responding to an office action. It's actually a fairly complicated formula for a patent term adjustment. The patent office will automatically inform someone at the time a patent is being received how long, if any, they have to add on to their patent term. And if one wants to check that, if it's an important patent, one usually has to use a commercial piece of software or a commercial service that adds it up. Now, patent term adjustments are common in the US. Historically, something like 80% of US patents in recent years have received an adjustment, but on average, they're pretty short. So they're close to 6 months. More recently, like the Brazilian Patent Office, the US Patent Office has been working on reducing its backlog and has shortened reply periods. So last October, the most recent month we have data from, only about half of applications now received a patent term adjustment, and on average, they were significantly less than 6 months. So in all of that, you have a couple major differences between these systems. Patent term adjustments in the US are evaluated very much on a case-by-case basis of delay. And while they are common, they're also fairly short. They're at least significantly shorter than one encounters in Brazil. And of course, the applications have a very different pendency time frame between the two. And that's important for another reason, because Brazil and the United States have different systems with respect to remedies for retroactive infringement. In the United States, as a general matter, you don't get retroactive damages for a patent during the application process. In other words, once a patent grants, you can then get damages or potentially an injunction against an infringer, although injunctions are not mandatory. And since 2006, a patent owner has needed to show that they have suffered irreparable harm to get an injunction. And those are highly fact-specific determinations. At the end of a trial, something between 50 and 75% of cases have an injunction issued in them. But now there are robust systems for challenging patents and post-grant appeals, and there is a very high level of settlement. And so it is not that common to get to that stage and to have a judge determine whether or not an injunction should be granted. But in any case, damages are not generally based on competitive activity that occurs before a patent issues. There can be a reasonable royalty granted for infringement that occurs after an application is published, but before the patent issues, if an infringer had actual notice and the claims that issue are substantially identical to the published claims. But in Brazil, under Article 40 of the Industrial Property Law, anyone entering the market between the time of the application publishing and the date of the patent issuing is at risk of being liable for their profits. So this is a much more substantial form of liability that has a much greater chilling effect on a competitor being willing to enter the market. There is substantially more risk in Brazil, both because of much greater potential damages. In the US, you're only looking at a reasonable royalty. And because in the US, you will know pretty quickly whether or not a patent is going to be issued. You are generally going to know this in less than 2 years. And because patents are issued in 18 months after a non-provisional filing, there is really only a 6-month delay on average between a patent publication and an issuance. The US is a bit of an outlier in that applicants can choose not to publish their applications if they're only filed in the United States, but this will prevent a reasonable royalty from getting granted in the first place. So if you go to Brazil, a competitor may be waiting 13 years on average to see whether or not this patent is going to issue. And during that entire time, if they are operating in a way that is ultimately held to be infringing, they may be liable for the entire profits of their enterprise. So far fewer consumers or competitors are going to be willing to enter a market under those conditions. And so this is going to reduce competition and result in higher prices for consumers. You know, Perhaps the most troubling aspect of this may be that a competitor may be held out of the market for something like 13 years, waiting to see if a patent will issue, and the patent may end up not being issued and being determined to be invalid by the Brazilian Patent Office, but there's really no way to know that definitively in advance. If a patent is issued in the case of a generic drug, a competitor may hold off development for 13 years, waiting to see what happens, and then have to wait an additional 10 years under Article 40 if a patent is issued and benefits from this. So you have very different situations with competition, with the pendency of these applications, with Article 40, and with these other features of how the US and Brazil differ in their remedies and their process for patent applications. All of which ties into a next major issue, which is parallel importation. So once a product covered by a patent has been sold with the patent holder's consent, the patent right is said to be exhausted and can no longer be exercised by the owner. This is the exhaustion or first sale doctrine, and that is fairly universally the case domestically. But there is less consensus on international exhaustion. So whether a drug legally sold in Mexico could then be imported and sold in Brazil while there is a Brazilian patent on the drug. In 2017, the United States Supreme Court weighed in on this issue for the first time in the case of Impression Products v. Lexmark, and the Supreme Court confirmed the doctrine of international exhaustion applies in the patent context. This was several years after the 2013 case of Kurtzsang v. John Wiley & Sons, which upheld the doctrine of international exhaustion in the copyright context. And that case was careful to say that the Supreme Court considered copyright and patents to be really two very different issues here. But in both contexts, there is international exhaustion. In Lexmark, the court held by a 7-1 majority that an authorized first sale anywhere in the world exhausts US patent rights, including the right to prevent importation. So if you have a drug that's patented in the US and sold in Mexico, whether or not it's patented in Mexico, as long as there is consent by the patent owner to the first sale, and whether or not that consent is express or implied, there's nothing on the patent side preventing the drug from being legally bought in Mexico and then imported into the United States and sold there. What that does is it prevents there from being much of a price difference between the two countries. At some point, if you're selling a drug for much less in Mexico than you're selling it for in the United States, some enterprising person is going to drive down to Mexico, buy a bunch of drugs, import them in the US, and sell the same drugs for less than the originator company is selling them for in the United States. The originator company doesn't like that, but there isn't much they can do about it except to sell at the same price in each country or stop selling in some countries, both of which are hard things for them to do for a variety of reasons. Or they put up with some competition during their monopoly term, effectively with them competing against themselves. That's parallel importation in a nutshell. Now, in the medicines context, the issues are a good deal more complicated because medicines are an unusually highly regulated industry. But in the United States, millions of individual consumers have now, for the past several years, been on a personal basis importing medicines, and the government is not intervening in this. But to do it for health system procurement, the Secretary of Health and Human Services, which is a high-level, medicines regulatory official in the US, has to certify a drug import as safe. That has been permitted since 2003, but it has only very recently happened with the Trump administration, which has been a very vocal advocate of parallel importation, about a month ago authorizing imports from Canada. This was a major event in US healthcare policy, and it is thus going to allow state and federal health systems to purchase drugs in Canada and import them at lower costs. And this is in large part because the US prohibits direct negotiation of drug prices in their federal procurement system. Amazon is now getting into drug supply also, and may prove a major driver in parallel imports at a consumer level. And all of this is likely to increase competition and to thus lower consumer and healthcare costs, but Brazil does not have the same system. So even if a patented product is selling for much less elsewhere in the world, an originator company can charge higher prices in Brazil and prevent people from importing drugs from Argentina. The EU is a little bit more like Brazil, so there is regional exhaustion of patent rights in a European Union country, but not international exhaustion, though there are some exceptions, as with the principles of implied licenses and patents in the UK. But generally, with patents in member states, national patents can be used to prevent imports. There's a third difference between US and UK systems I wanted to touch on, and that is patent extensions for regulatory approvals. Those are called patent extensions in the US, and they're called SPCs in the EU, and we already heard about those this morning. But both are designed to compensate for the time needed to obtain regulatory approval. And this is one area where, instead of Brazil providing higher levels of rights, the US and the EU provide higher levels of protection than Brazil. So in the US, patent term extensions have been available under a 1984 law called the Hatch-Waxman Act, after the law's sponsors. And this was the law that established a route for generic drug competition that's used today. And in return, it granted, a few beneficial provisions to originator companies, including patent term extensions. So an originator company can extend its patent term, and this is something that the US Patent and Trademark Office processes, for up to 5 years and not to exceed 14 years in total from a date of drug approval, by the sum of 1/2 of the time in its testing phase plus all of the time spent in the review phase. And subtracted from this is times that the applicant wasn't proceeding with diligence. For this to happen, a patent has to have at least one claim covered by an approved drug product. The patent can't have expired. The patent term cannot have previously been extended. The patent owner has to apply for this. It doesn't happen automatically. The patent has to have been subject to, the product has to have been subject to a regulatory review before its commercial marketing. And this has to be the first commercial marketing of that particular product, right? So this would occur when you have a drug going through phase 1, phase 2, phase 3 trials, and either under a new drug application or a biological drug application, which can take up to 8 years or 10 years or sometimes more. And so you get 5 years tacked onto your patent. I won't go over the SPC process because you heard that, and now you're all experts in it, but it's broadly similar. In Brazil, there is no procedure like this to renew a patent or extend its term, even where there are delays related to marketing approval. But as a practical matter, obtaining regulatory approval with Anvisa is much faster than with the FDA. Those approvals often track FDA approvals, so there's much less administrative delay with drug approval than you get in the United States. So those are some of the general ways in which Brazil and the US and the EU differ from one another in terms of the TRIPS plus protections that they do grant, at least with respect to patent term adjustments, extensions, and parallel imports. So are these TRIPS plus protections good or bad? Well, to give the lawyer's answer, it depends. It depends whether we're considering these costs and benefits from a national or global perspective, what stakeholders we're thinking about, and what sort of public policies we want to pursue. So let's take a step back and think about why we grant patents. And there's basically two broad theories on which they're granted: as economic measures and to protect moral rights. On the economic side, patents are incentives. They're innovation incentives because they encourage people to invent things and they encourage investment in research and development. The cost of innovation can be significant, and there may not be significant barriers to copying some types of intangible ideas. And so we would expect without patents an underinvestment in socially valuable research and development because no one wants to invent things that other people can free ride on. Patents are one solution to this problem by allowing a patent holder to charge monopoly prices for their inventions and thus to generate a greater return on investment. That reasoning, as you heard earlier, is sometimes challenged on the basis that, for example, innovation isn't always risky or expensive, and there are lots of ways to profit from an invention besides patents and so forth. But if that reasoning does hold up anywhere, it probably holds up most of all in the pharmaceutical industry. And perhaps even there less for a patent's role at incentivizing innovation than in incentivizing commercialization. Because commercialization incentives are critical in the pharmaceutical industry, where the originator industry claims that new drugs cost around $2 billion and take around 8 to 10 years to get market approval. So it is often not the initial discovery of a new drug that is the difficult part of drug discovery, but all of the clinical testing and regulatory approval required to get that drug on a market. And if a company had to spend all of this money and take all of their time getting a drug approved, and anyone else could come in quickly and make the same drug, we would expect to have underdevelopment of new drugs. Though again, there are other ways to protect new drugs aside from patents. Data exclusivity, as you heard this morning, is a major one, and this can prevent or delay generic companies marketing a competitive product, even in the absence of patent protection. And then trade secrets can also provide, in some cases, major routes of protection. Biologic drugs, for example, can be very difficult to develop generic or bioequivalent versions of them. Or some drugs like Premarin, for example. Premarin has been approved by the US FDA since 1942, and there is still no generic version of it because the manufacturing is protected by trade secret very effectively. There's another valuable aspect of patents, and that is that they encourage disclosure of information. So if patent protection was not available, originators might be inclined to protect their inventions under trade secret or confidential information law, and the public would lose out on the benefits of learning how to make, use, and sell a new product. It would thus kind of fail to go into our general store of knowledge. Of course, trade secrets only work in some contexts. They don't work, for example, where one can reverse engineer a product, or they may not work where a originator company has to disclose certain information publicly related to a new drug. But if you hire the right IP counsel, you might find someone cleverly able to put together trade secret, data exclusivity, and patent protection for your new product. Patents also protect moral rights, but those tend to be a lot less invoked in the context of patents than in other forms of IP, like copyright, where authors may receive various forms of protection independently from copyright owners. But they still play a role, and in this context, largely along the lines that it would be unfair or unjust not to respect someone's property rights, regardless of the economic arguments. So in light of all those reasons for patent rights, do these TRIPS plus protections hold up? Well, you heard a skeptical view again this morning that they were really justified. I'm a little less skeptical than Ellen, but one of the problems in setting policy in this area is that drug markets and drug development are very complex, and that pharmaceutical research and development is not terribly transparent. Whether a patent or whether an extended patent term makes the difference between a new drug being approved or not is ultimately an empirical question. And originator companies haven't clearly made the case that they need these protections to have these new drugs come out. More of the argument is simply that more IP protection is greater encouragement to invest in pharma companies, to have pharma companies invest in R&D, and pharma companies investing in R&D is how we get almost all of our new drugs. So under that reasoning, it would result in more public health benefits. I think a fair description of the situation in the UK and the EU right now is that these are very hotly debated issues, and issues that have now been very much moved to the forefront of public debate on account of COVID. But whether or not the US and the EU should be effectively subsidizing originator pharmaceutical companies is a very different question than whether Brazil should be subsidizing pharmaceutical companies for a couple of reasons. First, Brazil represents a very modest portion of the global market for originator drugs, so a longer term of patent protection in Brazil is very unlikely to ever make a difference between the number of new drugs developed internationally. Pharmaceutical companies innovate in the global market and make the vast majority of their profits in the US and the United Kingdom and some other jurisdictions. And so whether they can get a patent on a drug in Brazil is unlikely to make a difference between whether or not they move forward with a particular drug, much less the issue of whether they can get a few extra years of protection on a patent in Brazil. More likely, it's just going to be the case that if they can get a patent in Brazil or a few more years, they're getting a windfall, an extra term of protection in Brazil than they get anywhere else, And this is, again, a windfall that is going almost entirely to foreign national companies. Given that about 80% of patents in Brazil are held by foreign entities and a much higher percentage in the fields of pharmaceutical and agrochemicals. So you have a system here where Brazil is basically paying subsidies out of its national healthcare budget to foreign multinational companies, and not where Brazil is generating innovative R&D through these policies. If you do believe generally that, well, more profits for pharmaceutical companies are better for everyone because they can invest in drug development, well, that may be true, but in that case, you might as well just send them some money. What about domestic companies, though? Well, even leaving aside the fact that Brazil is a net importer of pharmaceutical and agrochemical innovations, whether or not Brazil itself is providing TRIPS Plus protections has no impact on whether or not the US and the EU are providing TRIPS Plus protections. So if these TRIPS Plus protections really are generating a lot of value for pharmaceutical companies, that value still flows to Brazilian companies, because if they are generating either originator drugs or innovations in generics that have value at a substantial level, they can file for patents in the US and EU and enjoy national treatment and still enjoy the SPC provisions and the patent term adjustment and the patent term extensions granted by the US. Brazil does not have to provide those same sorts of protections for Brazilian companies to enjoy them abroad. And as to the argument that it's wrong to deprive companies of their property and that they deserve at least 10 years of protection, well, they are hardly going unrewarded if they are generating a valuable drug that is protected in other large jurisdictions. And because they get to seek profits retroactively for infringement after a patent grant, they really aren't losing much in terms of not having earlier patents. And what is the cost of providing more protection than Brazil needs to? Well, it is decreasing access and resulting in higher costs to the healthcare system and to consumers. Earlier patent expirations and earlier determinations about patent validity would lead to more opportunities for competition and would drive down costs. It is hard to quantify some of those costs given how complex these markets are, but last year there was a study by researchers at the Innovation Economics Group at the Federal University of Rio de Janeiro, which reported the average duration of pharmaceutical patents is 23 years, and that over 10 years, those extensions for 9 drugs alone will cost the Ministry of Health about 4 billion reals. For example, in the case of dasatinib, which is a leukemia drug, Brazil's Ministry of Health pays about 80 reals per pill versus about 15 reals in India. That's because the patent has expired in India, but the patent will enjoy protection in Brazil until 2028 because the IMPI took 18 years to analyze the application. The same system is true of allowing parallel imports. So if Brazil has a patent in force that's absent from other markets, Brazilian consumers would again experience improved access and price from allowing international exhaustion, even if the competition there is really coming from one different pharmaceutical company operating in 2 different markets. So what are some of the things that Brazil might do to improve public health, access, affordability, and to promote competition? Well, one of the easiest solutions would be to have the patent office reduce its backlog. And it's my understanding that this is already a priority for the patent office, which is already making impressive progress at this task. But it should not come at the cost of reduced quality examination, given there are substantial costs with issuing bad patents. There was, I understand, some years ago a proposal that simply all the patents in the backlog would be granted, and that would not have been a good solution. A better way of dealing with the backlog, at least given Brazil's current position, is to do what India does and require applicants to report all international patent office activity and take advantage of work done by other offices like the European Patent Office that can help Brazilian examiners determine whether a patent is valid. And I understand that that is one thing that the Brazilian Patent Office is already doing. But to the extent that more funding is required to hire more examiners to maintain high levels of examination, right, even though this may have an upfront cost, it should result in a substantial cost savings to the Brazilian healthcare system that would more than offset that. And it does seem that the Brazilian Patent Office is not a mere rubber stamp of applications. A study this year that looked at a sample of 613 pharmaceutical patents granted in the US due to expire between 2018 and 2022 found that only about 60% of those were filed in Brazil, and of those, only about half received Brazilian patents. So only something like a quarter of US pharmaceutical patents are ultimately issued in Brazil, and that is both because of priorities of companies. It is expensive and uncertain to file in Brazil. They may abandon projects by the time Brazil gets around to examining something, but also Brazil does have different standards of patentability than the US, and so it is clear these are being applied, at least to an extent. More ambitiously than the patent office, reducing its backlog while maintaining a high level of examination, is that Brazil could remove some of these TRIPS plus aspects of its law. For example, it could remove the requirement to provide a minimum of 10 years of protection. It could allow only a reasonable royalty on retroactive infringement rather than disgorgement of profits, and it could allow international exhaustion of IP rights. That is something that is clearly permitted by TRIPS, and indeed it is something done by the United States. And I do understand there's a case currently pending in the Brazilian Supreme Court on the 10-year minimum term and its constitutionality, but the wheels of justice turn slowly. In the meantime, it is costing the public health system a great deal of money. Right now in the US and in the EU, these issues have taken on renewed importance. And we see, for example, a front page article in the New York Times this week about suspending intellectual property rights. So IP rights in the context of drugs have gotten a lot of attention, and it is a very controversial area. And if we can't even decide that these are necessarily good things in the US and the EU, well, that's all the more reason that they're clearly not a good thing to have in Brazil. TRIPS plus protections benefit foreign companies at the cost of consumers, and they benefit originator companies rather than generic companies. And Brazil isn't in a position where it benefits really from either of those dynamics. And to the extent Brazilian companies are patenting innovative R&D, either as originators or as generics companies, they can still benefit from TRIPS plus provisions in the large established markets for those products, like the US and the EU, without having to provide the same benefits. So if there are some benefits to the terrible COVID pandemic, perhaps it is an opportunity for us to reflect on the way that we've been doing things and to realize perhaps that there are some things we could be doing better. Thank you.